Welcome to K&L Gates' Working Wise podcast series. My name is Nickolas Spiliotis, and I'm a partner in the Houston office of the firm's Labor, Employment, and Workplace Safety practice area. In this podcast, I will discuss employer responsibilities when a natural disaster hits. There are a handful of slides that accompany this podcast. Wage and hour issues remain the primary concern for employers when a natural disaster hits. Employers should look to specific employment agreements and handbook policies, as well as collective bargaining agreements that may be in place to determine what pay employees are owed. Assuming those agreements and policies and no state laws require additional protections, the Federal Fair Labor Standards Act, or FLSA, will set forth the minimum requirements employers must adhere to. For hourly non-exempt employees, the Fair Labor Standards Act only requires pay for the time actually worked by these employees. For this reason, employers who are shut down because of a natural disaster need not compensate workers who are not working. This is the case even if it is the employer's decision to close a particular worksite and no mandatory or recommended shutdown has been ordered by state or local authorities. However, employers should be aware of reporting time pay laws that exist in 8 states and the District of Columbia that require employees to be paid for showing up to work if their employer requires employees to actually report to work on all scheduled work days, even if they are then sent home. Some cities and states also have predictable schedule laws that require employees to be paid for scheduled work days if no adequate advance notice of a schedule change has been issued to the employees. Such laws often exempt unpredictable weather events, but employers will want to be diligent in monitoring weather forecasts and providing notice of closures as soon as possible. Now, exempt salaried employees must be paid their full week's salary as long as they work part of the week. However, employers can require exempt employees to use their paid time off, their accumulated leave or vacation time, for the days they do not work. I typically have discouraged clients from doing this. An interesting scenario does arise when an employer chooses to remain open for business when inclement weather or a natural disaster hits, but the employee decides not to come in. In those situations, an employer can use an exempt employee's accumulated paid time off, and if the employee has no accumulated time off, the employer can choose to not pay for an entire day's absence. If, however, the exempt employee works a little that day, the full day's salary must be paid. Employers should be especially cautious in deducting pay under such circumstances, since many exempt workers perform work remotely. With respect to hourly non-exempt employees, all time work must be compensated. This includes work performed remotely. For this reason, employers are wise to have policies that clearly address what constitutes compensable time and require accurate recording and reporting of such time so as to avoid potential wage and hour disputes from arising. State laws typically require that hourly non-exempt workers be paid at least twice a month and exempt workers at least once a month. If the timely payment of wages does not happen, employers face monetary penalties. In the wake of a natural disaster, some states have chosen to waive such penalties, but employers are required to advise employees of the delay in processing payroll, notify employees of their new expected payday, and pay as promptly as possible. Failing to do all of the above could result in penalties. Of course, one easy way to boost morale is for employers to go ahead and issue voluntary or expedited payment of wages, as there are no restrictions on doing so. Some states, including Texas, have statutes protecting employees who leave their place of employment in order to participate in a general public emergency evacuation order. The Texas statute actually protects both mandatory evacuation orders and voluntary or recommended evacuations. Since local mayors and county judges are often in charge of emergency responses, employers need to carefully monitor local announcements. Under the FMLA, or Family and Medical Leave Act, which generally applies to employers with 50 or more employees, qualified employees are allowed leave from work due to a serious health condition or to care for a spouse or child with a serious health condition. For this reason, employees should keep up with employees during a natural disaster and monitor for injuries affecting their employees or their family members. The ADA and the Americans with Disabilities Act Amendments Act provides reasonable accommodations to qualified employees with disabilities. Notably, emotional injuries such as post-traumatic stress disorder are covered under the Act and are legitimate reasons preventing some workers from returning to work or justifying additional time out of the workplace. USERRA, the Uniform Services Employment and Reemployment Rights Act, prohibits private employers from terminating the employment of an employee who is a member of the military forces or National Guard because the employee is ordered to duty during a natural disaster. Texas and many other states have equivalent laws that apply to state military force personnel. Notably, USERRA and equivalent state laws apply to all employers regardless of their size. In the aftermath of Hurricane Harvey, a significant number of employees requested to take time off from work to assist with relief and rescue efforts all around the city, even though they were not personally affected by the flooding. Relaxing normal rules for leave is something I encourage employers to do. However, employers should make sure they apply the relaxed rules consistently across the workforce so as to avoid any claims of discrimination. Inclement weather and natural disasters routinely affect unemployment claims. Failure to show to work during inclement weather is often not considered misconduct justifying termination in an unemployment claim before the Texas Workforce Commission. Some states also extend the time period employees can receive unemployment benefits if they have lost their job as a result of a natural disaster. The Disaster Unemployment Assistance Program provides unemployment benefits to individuals who are self-employed and don't normally qualify for state unemployment benefits and who live or work in counties made the subject of a major disaster declaration by the President of the United States. The Worker Adjustment and Retraining Notification Act, or WARN, requires 60 days notice prior to a plant closing or mass layoff. A plant closing is defined as the permanent or temporary closing of a facility with 50 or more full-time employees. A mass layoff consists of a layoff of 500 full-time employees or 50 or more full-time employees constituting at least 33% of the workforce. Although the Act allows for shortened notice when a plant closing or mass layoff is directly caused or an indirect cause of a natural disaster, the burden remains on the employer to show this, and employers will want to be familiar with the WARN reporting requirements and give notice as soon as possible. The Disaster Relief and Emergency Assistance Act allows employer payments to employees without any income or payroll tax consequences where a federally declared disaster results in expenses that have not been adequately covered by insurance. Such expenses include payments to reimburse or pay reasonable and necessary personal, family, living, or funeral expenses, or to repair a home or replace contents in a home. The Internal Revenue Service can also open up 401k and other employer-sponsored retirement plans to make loans or hardship distributions to employees, which they did after Hurricane Harvey. The last slide includes general tips for employers. In short, I recommend employers have written policies in the event of a natural disaster and confirm their payroll policies comply with the FLSA and state and local wage and hour laws. As storms approach, employers should remind employees of the established protocols. Employers should also take steps to confirm employee contact information is current and accessible to the staff who will communicate office closures to the employees and will remain in contact with employees while the workplace is closed. We hope you enjoyed this episode of K&L Gates' Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com.